Hello, welcome to our monthly webinar series. Sharon Urias and Justin McNaughton here. Thank you for joining us to talk about holiday trademarks. As you probably know by now, Justin is a trademark prosecutor and I am a trademark litigator. Please feel free to submit your questions in the question and answer box. We will have a question and answer series at the end of the webinar. So just to sort of go back to the basics, let's talk about quickly a refresher on what trademarks actually are. Trademarks are brands. They identify the source of goods or services, and they tell the consuming public that you are the sole source of the goods or services that you offer. And there actually is a hierarchy in terms of the strength of trademarks, right, Justin? I mean, not all trademarks are created equal. The highest level of protection that a trademark can get is for an arbitrary or fanciful mark. So an arbitrary mark is one that has nothing to do with the goods or services that are being offered. For example, Camel for cigarettes or Apple for computers. A fanciful mark is a made-up name, something like Clorox or Kodak. Those words didn't previously exist, and so they achieve the highest level of trademark protection. Just below arbitrary and fanciful marks are suggestive trademarks. And these are marks that suggest characteristics of the product or service that's being offered under that mark. It requires consumers to draw a conclusion based on the name as to what the good or service is that's being offered under the mark. An example is Coppertone for suntan lotion, Netflix, or Airbus. They suggest what the good or the service is, but they don't come right out and put it in your face.
So it's not quite as obvious, right? Like you have this, you have these marks, but you don't instantly go, oh, I know what that is, which leads us to the next couple of categories, which are just the kind of disaster categories of trademarks. So you have descriptive marks, which, and I hesitate to call them marks, but you have these phrases which are descriptive. One would be like a lemon car freshener, and you instantly know what it is, where it is, and how you use it. Fresh tomato soup would be another one where you instantly know what it is and what flavor it is and that. And so it describes so much about the trademark that the trademark office won't let you have that because it would prevent other people from describing their own product using the actual words to describe it. So those are descriptive. So we try to, as trademark lawyers, keep people out of that as much as
you can get trademark protection for a descriptive mark, right?
You can. It's just a lot harder, as opposed to the next category, which are called generic. And generic trademarks are things that are they're almost the proper name for what you're trying to describe. An example would that be like used books. So if I'm going to sell used books, I can't call myself used bookstore because there isn't a good other way, to describe that. I mean, gently used perhaps, right? But used bookstore is the phrase, or car rental.
Trademark protection for those.
So you cannot get a trademark at all for generic marks. And so now descriptive is a little better, but you usually have to disclaim, which means you can't protect those words that are descriptive. And for context, why this is important is that probably 80% of trademark fights are over these descriptive and generic trademarks, where somebody's using something and it's on this line where it's pretty descriptive, and they end up in this big fight with a third party because everybody's trying to use those same phrases. And then the whole fight is over whether you actually have trademark rights in it. So you're much better if you're starting from scratch. You're much better to start with just make up a word or use some word that, that has no meaning in your field, like Amazon, right? It has no meaning in delivery. Even though at this point, people have forgotten that there's a rainforest, with that same name. So that leads us. So what we wanted to do today is run through a bunch of holiday trademarks that we found and illustrate some of these concepts in them. And the first one we want to start with was How the Grinch Stole Christmas, which Dr. Seuss Enterprises has at least 15 trademark applications and registrations for that phrase, How the Grinch Stole Christmas. And then they've got, I think, well, including that 15, I think they've got another 15 or so for the word Grinch. And they're for toys, clothing, candy, fabrics, all sorts of different things, as well as films and books. But the thing that's weird about these, when you see a phrase like "How the Grinch Stole Christmas," you aren't like, "Oh, that's the Coca-Cola company," right? Like it doesn't feel like a normal trademark. How the Grinch Stole Christmas. You're like, "Oh yeah, I know that company." It doesn't feel like a source.
With Dr. Seuss, right? Which is the actual source of goods.
Right. And so these ones are a little bit strange because, and don't get me wrong, they have trademark rights in these, so I would not recommend that anybody and they're aggressive about them. But it was an intentional move to really develop and get that trademark and use it in these goods. This is not a normal way to do it. They set out to take this book title and turn it into a trademark, and they've successfully done that.
It's very interesting. The next one that we found is the Dreidel Company. And so if I said to you, hey, I heard of this business called the Dreidel Company, what would you think that they sell?
I mean, my first guess was spinning tops.
Exactly. Dreidel spinning tops. And in fact, somebody tried to get the Dreidel Company tried to get a registration through for spinning tops, but that was denied by the USPTO because it's merely descriptive of the goods that were being offered under the brand. But another company, or it may be the same one, I'm not sure, called the Dreidel Company, was able to get a registration through for candles. And what's interesting about this one is that candles are highly related because you associate dreidels with Hanukkah and you associate candles with Hanukkah, but it doesn't come out, the Dreidel Company doesn't come out and just describe the product that's being sold. And so that's really the only reason they were able to get that registration through. Although as a side note, I do find it kind of confusing that the Dreidel Company offers candles for sale, but irregardless.
But that's actually what turns it into a trademark, right? The fact that it's a little bit confusing is what makes it registrable and what makes it protectable, because you don't instantly say, oh, they must be selling candles.
Right. And
so
when people are starting businesses, I think their instinct is to come up with a brand that describes the product so that people will know immediately what they're doing. Whereas the better approach from a trademark lawyer's perspective is to, ideally find a strong suggestive mark.
Yeah. So that leads us to the next one, which is one of my favorites, is the ugly Christmas sweater. So this is the next trademark that we ran into. And there have been at least 22 different applications for ugly Christmas sweater. And 17 of them were by the same company called Crown Jewels. So to give you some context though here, where we're going to have some trouble is that of that 22, 14 of them have been refused. And of Crown Jewels, of their 17 applications, 11 of them are refused. So which means they've really struggled with this. But as you go through, they filed for things like notepads, tree ornaments, stickers, coloring books, wine bags. But all of these have a depiction of an ugly Christmas sweater on them. And so they all get either moved to what's called the supplemental registry, or they have a disclaimer where they have their trademark, but they're not actually allowed to. What? Sharon's, well, I guess 63% were okay. We'll call that a draw, even though you got. Oh, I'm sorry. I'm not sure if everyone can see that. So 63% of you said that we're both awesome. Both sweaters are awesome. And Sharon edged me out slightly amongst the rest. Well, slightly, 25% to 13%. So. Anyway. Well, okay, I guess you can see it. Okay.
Christmas sweater trademarks is that nobody can get ugly Christmas sweater for ugly Christmas sweaters, can they?
So you can't, you'd have to do it as a design. And you really can't get ugly Christmas sweater for sweaters because I mean, they are not going to allow that. But what they've done here, and the other problem they had is that, so even where they've done tree ornaments, these tree ornaments were of ugly Christmas sweaters, right? So, and their notepads look like ugly Christmas sweaters. So that's why they're getting these they're getting required to disclaim these things and not getting protection, because even though they look like they're unrelated goods, in fact, they all are ugly Christmas sweaters. So the disclaimer means that once you've disclaimed something, you can't stop somebody else from using that phrase. So
Right. So if you
here,
register my ugly Christmas sweater, but you say, I don't claim exclusive rights to use ugly Christmas sweater, you basically have no exclusive rights.
right, exactly. And when that happens, you get pushed to the supplemental registry. You can't disclaim everything in your application without going to the supplemental. Usually what'll happen is there's some other element like a design, and then you disclaim all the words. You still have registration, but it doesn't cover the words, and it's a little bit, it can be a little confusing. So
Well, what I like is that the next one, somebody actually was bold enough to try to get a trademark registration for the Christmas Tree Company, as if they're the only, company in the United States that's selling Christmas trees. And so, of course, that would be refused if they just tried to get the Christmas Tree Company. What happened, what these guys did to try to be a little bit clever, is they created a design mark. A design mark means you're not just trying to get the plain characters, the Christmas Tree Company, but you're actually getting it in a stylized font, maybe with a logo, a design around it. And what the USPTO is, they allowed that design mark through, but they made the company disclaim exclusive use over the Christmas Tree Company, which basically means they have very weak rights, I think. And in fact, this registration ended up being abandoned. So,
although I think that may have been because of what they were doing and not because of their trademark. I think they got it through, but it was for online sale of Christmas trees. And so we're like, I'm picturing in my head FedEx driving around with a whole bunch of trees tied to the top, and I can see how that
probably not
might
the
have
best.
been
Yeah.
difficult. So the next one Sharon assigned to me because it's almost impossible to say,
That's right.
and it's happy Hanukkah Kwanzaa.
You did
So
that pretty
happy,
quick.
did I get that right?
Yeah, I think
Happy
so.
Hanukkah Kwanzaa, and it's for greeting cards. This one is the reason we picked this one is interesting because this one actually could be, I mean, it is eligible for trademark because it doesn't actually describe a real thing. And it's for greeting cards. But the problem that she would have in this application, she didn't get that far, but the problem she's going to have is that it seems to me that this phrase is something that you would see across the top of a greeting card. And it's not actually, it doesn't lend itself easily to the source identifier. It's not Hallmark. It's the clever phrase that you put on the front of the card. Unfortunately, the application was kind of doomed from the beginning because it had a whole bunch of problems in it, including that filed the wrong statement of use. She filed a PowerPoint describing how she was going to use it as opposed to actually an actual specimen showing it. So we will never know, but that's what I suspect would have happened with that application.
Probably should have hired a lawyer to do it for her. In any event, the next one that we found was kind of a fun one, Kwanzaa clause. And I guess that's not really a thing. There is no Kwanzaa clause, just in research.
No, I looked this up. It's not, there is no Santa Claus at all tied with it. And so that's what makes this an interesting mark.
Right. So anyway, they were allowed to get that mark through for toys and movies without a disclaimer.
Right. And you can do that where if you take something, and all of a sudden, if it doesn't quite sync up with what you're doing, like here, everyone's familiar with Santa Claus and everyone's familiar with Kwanzaa, but when you put those things together, that incongruence is what can get you a trademark because it's not normally used that way.
Right. So if they were selling dreidels, they would really have it made, wouldn't they?
Right. Because then absolutely. And that, now the next one, is a little more difficult. The next one is the Kwanzaa Yoga Challenge. And this is a terrific example of a descriptive trademark, because you can guess immediately what they're doing. And the description is organizing events in the field of Kwanzaa through yoga for cultural or educational purposes. And they do have some awkward language in there, but you get an instant idea of what they're doing. And this was actually one that was forced to go to the supplemental registry because it's so descriptive, the trademark office would not allow it. And just, supplemental registry, again, just, it gives you a few rights. It does not give you full trademark rights. One of the ones that's missing is exclusivity, and you can't stop somebody from using that phrase. So anybody who wants to would be free to start their own Kwanzaa yoga challenge, because this they couldn't stop you with this registration.
Right. Well, and the next one, and I like this one. I think it's a cute name, Latkes and Vodkas. What's interesting about this one is the USPTO actually refused it as merely descriptive for entertainment services, meaning putting on parties. I disagree with that, and the applicant did not challenge the USPTO, but I think, Justin, that it might have been able to get through if they had been able to establish. I mean, I think this is suggestive of what it does at a party.
I agree. I totally agree.
Right. So,
but I don't hear latkes and vodkas and think like, oh, that they must do party planning services, right? Like,
no,
I don't see that at all.
And vodkas.
Right. And it also has some like clever alliteration in there. So I think that they had, excuse me, I think
they were onto something.
I think they were, and I think they could have pushed back and probably gotten that through. So that's a bummer.
That is a bummer.
And then we arrive at the last one that we had before we do some questions, which is COVID Christmas. And Merry COVID Christmas, a long holiday tradition there. So we have here, and what this one sets up, and then actually between the time that we did our first set of notes and today, someone else filed a COVID kinda Christmas. Now, what's interesting about these is that all three of them were filed for clothing. And one of them was filed in August, one was filed in September, and then one of them was filed like 5 days ago. And for trademarks, now these are going to have some problems, but there is no such thing as COVID Christmas, or at least there hasn't been up till now. So they're gonna have some. They won't have the same descriptiveness things for clothing that we've talked about before, but only the first one is, if this gets through, only the first one is going to get it, because you have this issue of only if they're confusingly similar to each other. And you see that by adding Merry COVID Christmas doesn't materially change it from COVID Christmas. A COVID kind of Christmas, maybe, but probably not, since it's clothing. So two of these are going to be terribly disappointed this year at Christmas.
I agree. And they have that other problem that we've talked about in the past, which is that if they're for clothing, chances are it's just a t-shirt that says COVID Christmas on it, or a COVID kind of Christmas, which means that the mark is being used in a merely ornamental fashion as opposed to as a brand. The difference between having the little Izod alligator, which designates it as a brand to the Izod company, versus just some sort of logo. And what we have found in our practice is that it's common at this time of year in particular for the trademark trolls to come out and demand licensing fees. So, for example, they claim that they own a brand in something like Frosty the Snowman, and then they try to extort licensing fees out of other companies or people who are selling t-shirts that display whatever that ornamental image is. They threaten lawsuits, they issue takedown notices, and there really is a spike in that sort of activity at this time of year. And there are different ways you can deal with it. If you're making a lot of money selling your t-shirt that says Frosty the Snowman or Merry Christmas, you filthy animal, then maybe you want to push back against the trademark trolls by not giving into their demands, or even filing a cancellation notice if they somehow were able to get their mark through.
Right, because usually you have that same issue where, like you just described it, if you're using it as an ornamental feature of your clothing, that's not the same as using it as a trademark. And so there are things now. Unfortunately, it becomes expensive to fight about those things,
Right.
but but it's definitely something we see. But the trademark office does do its best to save the holidays for us all and
They do. Absolutely
reject those kinds of trademarks.
do. Should we take some of the questions that we have up there,
Yeah.
Jeff?
Let's see, just opening these up here. Do you want to do the first one?
Sure. So the first question is, do companies who create ugly sweaters need to get approval to use certain images and or sayings on their sweaters? If they do not get those approvals, are they actually penalized? So this raises the issue of how trademark law intersects with copyright law. And there are certain images that are copyright protected, just as there are certain phrases or brands that are trademark protected. And if you're going to be using, for instance, something related to a Dr. Seuss image, as we talked about earlier, and you sell it and you don't have a license or permission from the copyright holder, then you could be subject to some sort of copyright damages to the copyright owner. And some of the very valuable brands or some of the very valuable copyright owners of valuable copyrights will in fact go after people who infringe on their brands or other intellectual property interests. So it's always better to be err on the safe side. That's from our perspective, I think. But you always have to weigh the risk benefit.
Right. And a lot of times if so with some of these, a lot of times if it's a phrase where you actually made it up and it's just a decoration, you can usually push back on that. Trademark infringement is kind of a different deal. But again, it becomes so expensive to deal with things like that that
It
you
does.
just kind of want to be careful.
And what's happened online is because so many people in the marketplace use Amazon, what the IP owner does is they go to Amazon and they report you for selling what they claim to be an infringing good, and Amazon blocks you from selling. And this really presents a problem because during the holidays, it's hard to get those blocks removed quickly and you could miss the holiday season. So you really, I think, want to be careful in
You just
terms of
kind
what
of
you're.
search and see if you might have an issue. So the next one here is, how about trademarks for holiday foods like gingerbread cookies? So this is a good one. So an example of this is sort of Pepperidge Farm, right? Pepperidge Farm is the trademark, and then they may sell some sort of holiday cookies. I don't know if they sell gingerbread cookies or not, but say they sell gingerbread cookies. So you would be well served to avoid putting Pepperidge Farm on your cookies. But if you're selling gingerbread cookies, no one can stop you from saying, I, you know, these are my gingerbread cookies. That is a fundamental part of trademark law. And that is why all these other trademarks we've talked about have disclaimers in their trademarks so that they can't stop you. So to give it a good example of that would be, if a trademark that someone tried to register was Pepperidge Farm gingerbread cookies, they would have to disclaim gingerbread cookies, meaning that anybody else out there could still use the phrase gingerbread cookies to describe their cookies.
Right, but nobody can actually stop you from selling gingerbread cookies, by the way. The question that we're talking about is the brand name. The trademark is the brand. So if you were to try to trademark gingerbread cookie, that would be either generic, not entitled to any protection, or descriptive. Don't you think, Justin?
Oh, absolutely. That would be generic, almost certainly, unless now, yeah, there are some things you could do to try to do it. Like again, you could try to put a design on it, but you'd only be protecting the design, not the words. So
So the next question is, can you copyright or trademark a meme? So it's hard for me to give a definition of a meme, but my understanding is that it's some sort of um, funny or sarcastic image or phrase that's usually superimposed on another image or phrase, and it's throughout the internet,
Mm.
um, or displayed on the internet, I should say. So there's nothing unlawful about copywriting or trademarking a meme. It depends on what that meme is. Did you come up with it? Did somebody else come up with it? What is the image that's being displayed? What's the phrase that's being displayed? How common is it on the internet? It's very much a case by case basis. There's no general rule with respect to memes.
Although that one's interesting because a lot of memes have taken somebody else's photo and they've put text on it. And so in
Right.
that context,
They parried it, right? They parodied.
yeah. So you have parody, but if you were to take that kind of meme, so that's typically a copyright concept,
Mhm.
and then turn that into a trademark, meaning that you start selling goods and use that as a trademark. I think in that instance, you would get sued by whoever owns the photo because you've just turned it into a commercial use and you're now selling goods with it. So I think that you should, I think you could get yourself into some trouble
Could.
by.
Again, I think it really depends on what the meme is, right? And
Mhm.
who's being displayed. Is it, what's the phrase? Yeah. So it's, as I said, it's case by case.
See, we've got one more here. Um, if I'm a small company making personalized goods and a client requests a product with a common saying, do I need to look up trademarks if it's an individual order and not for mass production sale? That is a very, very specific question. So we are happy to sort of talk about that after, if you want to email us, that kind of thing. But just to give you some general kind of guidelines, if you are a print shop and printing things that come in, you can often get assurances from that person that they're not infringing somebody else's rights, that sort of thing. Um, it's not, and you can also do, if you want to, you can do your own search and just see if this is a phrase that is somebody's trademark. If it is, it should come up on a search. But a lot of times these common sayings like Merry Christmas um, are not trademarks. If it's just a saying and it's not actually a source identifier, then usually there's not going to be an issue. But if you take somebody's trademark and put it on a shirt, like back to the Pepperidge Farm, then you could get in trouble because somebody would instantly know that you took that trademark and converted it to a different reason. So hopefully that helps. But if we're happy to talk offline on more specifics.
Yeah. So I think that the USPTO does its best to protect the holidays from the Grinch or from anyone else who's trying to assert exclusive rights to use a mark and mess up everybody else's holiday season. Um, would you
Yeah,
agree with that?
I do, and I would just wish everyone a happy COVID holidays, and hopefully it's our last COVID
Yes.
holiday. So
Thank you.
thank you.